thanks a lot for joining. Rough idea, who is already working on some kind of legal tech automated stuff? Anything in that direction? 1, 2, 3. Okay. And who has a tech background, like can code a bit? Okay, good. That's more than usually at like privacy stuff. And I guess the rest is more lawyerish? Yes, okay. So that's actually a good mix for what we're doing here. Stefan is our tech guy that now works on a lot of that, but turns out I did the presentation before, so it's basically more organizational in what we did. So the idea is I'm just going to run through the whole project that we did and then have some time thereafter to talk. Now, being a workshop, the idea is really also, especially we try to improve the system we have and try to use it for other stuff and also share it with others. So while going through the presentation, it would be super cool if you have any ideas of what you did somewhere else that worked better, feedback or stuff that you would like to share or anything in that direction to make it then a bit more interactive. However, because what we did is a pretty big thing, I have like a decent slides collection of about 100 slides. But bear with me because it kind of explains what we did quite well and it's probably easy to understand that way. So we'll do that first and then go into more of a discussion probably thereafter. Before I was on a workshopy thing here before, kind of you have to go to this microphone up here, but we may also be able to kind of rotate it because it's a bit like in the school if you have to come up there and then talk. Okay, so what is this cookie banner project? The background on Neub, just quickly as an organization, we're a European organization based in Vienna. We do kind of strategic litigation, at least we try to be strategic, it's not always the case. We have about 6,500 members that pay for all of that, so we just have supporting members that support from €1 to ideally infinity, but not that much. The team right now, we have a board of 3 people, legal is roughly 10 people, tech is, I forgot to correct it, 3, and we're right now looking for another one, and PR is right now 2, admin 3 people, so just to have an idea of the size of organization we are. We kind of have 2 enforcement types, as we call it usually. So the one is kind of the standard setting cases, which is most of what we did at the beginning, which is more like, okay, there's 2 different views in the GDPR. We need to get the EDBB or the Court of Justice or someone to decide to have an idea of how this really works. Usually for that, it's novel issues. We try to invest more time into that. And there is very different than a normal law firm. We have really time to research for a month to bring a case and so on. Now, the other thing we have is pure enforcement cases where, sorry for that, where actually the legal situation is clear. It's just no one follows the law. And that from a legal perspective is a rather simple situation where you just like, okay, it's just about enforcing, not really about setting standards. And with GDPR in general, I'm just going to quickly go through that. We have this general compliance issue. We have oftentimes not the feeling of morale that people really want to comply. I was an ambulance driver in Salzburg instead of doing military, and you basically could run red lights as an ambulance driver. So you kind of lose respect over red lights. And then it's funny to see people at 2 o'clock in the morning as an empty intersection to still respect the red light anyways. And we have it somehow in our brain that is correct. We have to do it. And we do that from a sociological perspective. In GDPR, very much the opposite. Like we usually talk to people that are like, this is bullshit, this law should have never passed, fuck you with GDPR, we're not gonna do this. And that's a very different dynamic than in other litigations. So which had to kind of think how can we get more compliance with people done? And I have to say there's still very little evidence of how the companies really think, and we're kind of experimenting here. The idea is if there's a speeding limit, we should probably get somewhat to 30 kilometers an hour and not have like constant speeding, which is kind of like if you open a website right now, you will find 20 GDPR violations in 1 minute. And the idea is how can we kind of move that more into the right direction. So what we get, and I'm just going to quickly go through that from decision makers or from companies, is that there's this missing respect for privacy I already talked about. There's oftentimes missing legal understanding. We see that also with like people that apply with us for jobs. They oftentimes are in senior positions, but when they actually test them on GDPR details, there is still some shaky ground oftentimes. So we see that even in the professional people in the bubble, there is still some need to get the law probably right. There is oftentimes not that much interest in solid internal review. Like we hear this from data protection officers, that they're more seen as a pest than someone that actually moves stuff forward. And there is still this idea of risk instead of law. Like we're just going to see how likely it is that someone is actually going to do something about it instead of like saying that's the law, I have to comply with it. And overall, we have this missing seriousness. In addition, we have this tradition of non-enforcement. I'm not going to go into the details, but basically the authorities are still oftentimes in these informal solutions, try to kind of call companies instead of really enforcing stuff, hardly publish the decision, so we don't have that much of an enforcement culture. Like if you park in the wrong spot, you simply get a ticket and that's it. And everybody knows that that's it. In the GDPR bubble, there's still more of a flexible approach, if you want to call it that way. The other issue is that there has first mover issues. I'm just going to very quickly go through that, and I'm going to go back for that. Where we still have that idea of a lot of companies not really complying with the law, no one else is doing it, why should we be the first one? So there's a lot of these elements that we hear, why people, for example, don't have a compliant cookie banner. Like you get this whole list that I'm just going through as reasons. I'm just gonna try to go through that a bit quick. So I took that picture once in Rio over a favela, and I used that for a presentation a couple of times already. Because oftentimes it feels to me when you do GDPR that you are in the situation where technically there's a law that exists for building codes and I don't know, crime or whatever. But government kind of gave up to really get these straight lines anymore and have like houses actually built properly up to code. And it's very hard to overcome that. If you have a situation online where all the software was built one way, you would literally have to bulldoze a lot of it and build it new. And the resistance of that is enormous, obviously. And oftentimes compared it in Europe with situations where someone built in a nature protection reserve. We by now still bulldoze that house after all, but usually after a very long procedure and a lot of resistance. So we're thinking about how can we overcome that resistance, how can we change the metrics in all of that. And the situation we see right now is more of a spiral down. I mean, I know that on other panels today, it was talked that now we had the 1.2 billion on Monday, so everything works, everything is great. We more hear it the other way around. I'm a lot of business conferences where the people in business tell you, to be honest, we tried for 2 years to do GDPR compliant. It's hard, and actually there's no consequence, so why should we? And I have hard time to convince my management to actually do anything here. And that is the metrics that we try to change, basically, to get out of the spiral. Generally in law, there's two ideas. There's this idea of general deterrence. So if there's more trust in the legal order, if there's learning that there's consequences, people will themselves comply with the law. And that is oftentimes the missing element in the GDPR. There's no way that an authority can follow each individual website all the time. And we also don't do that in other areas. We just have enough deterrence that people generally comply themselves. That is the one part. Typical things in the GDPR we could do more with that is publication of decisions or also PR. I mean, basically, if everybody reads the big fines, that has a deterring effect on everybody else. The other thing you usually have is this individual prevention element where you say, okay, it's usually with individuals' integration into society, but also to protect others from that individual if you do enforce. So if you have that one website where... Sorry. Okay.
Just making good space.
That's very good, thanks. It's just like the wall is moving. Anyway, so okay. So the other part is this protection of others. So if you do have enforcement, you have that one website where you change the code, and that is good for the other 10,000 people, 100,000 people that visit it the next time around. And that's usually penalties or processing prohibitions that get you there. Now, our internal view, don't say that publicly all too much, is even if it's a speeding limit is 25, if we get them to 30, that's already good. So we didn't take an extreme view on all of that. There was a lot of questions in the projects we did why we don't have 5 other violations on top of it. And we tried with the mass violation to really focus on the biggest issues and deal with them effectively and do the smaller issues later, which is part of what we tried to do here. Now, that's kind of the background. Now there's the more individual background. We looked into cookie banners as a first big example, which was probably a good and a bad decision because cookie banners are extremely complicated technically. They all come in different shapes and forms and colors and all of that. So to kind of mass produce complaints or mass work on it, it's actually a tricky one. I'm just going to, for 5 minutes, explain a bit the background of what we researched before we started the whole project. So in very simple terms, I always say, if you can give up your right to life and you can jump off a bridge, I guess you can give up your right to privacy and consent, as we call it. And obviously no one would hit the consent button if that's the background, because that's terrifying. What they basically do is to say, hey, jump off a bridge, everything's great, and put the consent button there. And that is basically what the dark patterns are. It's like you try to kind of make it as reasonable as possible to consent, to get the consent rate up. And the industry calls that consent optimization. Like what generally is called dark patterns, there is a wonderful wording which is consent optimization. I tried to research on that, I hardly found anything. Once I typed in consent optimization, there's tutorials, there's online videos, there's all of that, how you can make your cookie banner so obnoxious that anybody's gonna consent. And that is basically where we started to go into. You all know the cookie banners where it's like on the third layer and you have to tick 100 boxes. We tried to then get more evidence on that because in the whole GDPR bubble, my view is that we're still oftentimes very much feeling and stomach feeling driven, and we tried to just get a bit more evidence on that. And that was, for example, the numbers from user-centrics. It's one of their guidelines where they basically say how much, what their consent rate is across thousands of websites. User-centric is a software that basically provides the cookie banner. They're called CMPs, consent management platforms. And you will realize that most websites you go, they look kind of similar. They may have different colors, but the general setup is similar. And bottom line, there's about 10 companies that do these cookie banners. There is some individual ones as well, but the bulk of it is these 10 companies. And the biggest one is OneTrust. And so we went for the biggest one to analyze that further. A typical situation that they said is, that is like an Austrian news page, is the biggest issue that they have is non-interaction, so that people just ignore the cookie banner. And it's amazing if you go through their tutorials, they say a lot of people, if that's the cookie banner here, which covers half of the page, would still read the page through the upper half, like in a window like that, just so that they don't have to click consent. Because kind of going to the no option is so complicated that people would rather like read websites like that than actually go through it. And that was interesting to me because I thought the biggest issue is people just click the consent button, but their bigger issue is people just stay inactive, and because that is not consent, they have an issue. So they try to cover up more and more and more of the page to make it more and more and more obnoxious to not kind of click on the button. The next thing that you found is that you have this kind of 3 options situation, which is helpful for them. And what was super interesting was also the second layer situation. So they say most people don't interact, and in their own numbers, they say only 2.1%, I'm sorry, this is not translated, 2.1% of the people actually go to the second layer. So if the consent button is on the second layer, by definition, 98% of the people don't see it. And that is the whole reason why it's there. And it's interesting to use their numbers also for the complaints because it's much more convincing and easy for an authority to be like, okay, that's what you did, there's numbers on that. The other thing is with colors, it was interesting that they said actually the more aggressive colors don't work that well. So if you do like a very kind of aggressive color, it usually doesn't work. But if you have the colors that are similar to the whole website, so in our case, it would be a pink button, that works better because it's not as intrusive. So they figured out people actually realize that that's a decision or some kind of bigger thing if it pops out from the rest of the website. If it's part of the rest of the website, it's actually more easy for people to just click because they think it's some random pop-up or whatever. That was, for example, where they said IKEA did that really well. They actually took that as an example because it's all black and white and their banner is also black and white, and then it kind of blends in more into the website than a gray banner or something that grays out the background and so on. That's all the details of the different stuff. What was interesting, that's a company that actually does consent optimization for everybody else. So it's an agency that kind of optimizes your cookie banner. And they do that for all these different companies. They were very proud of it, probably a lot of others too. And what was interesting is that in their presentation, they said 25% of people think that the website doesn't work if you don't consent, which is great for them because even though the website would work, people think they have to click it. So therefore, they would get to the consent. What was also super interesting, they say that only 3% of the people want to consent. Now that was for us from litigation perspective interesting because you could say, okay, 3% want it, but you get 90% consent rate. What happened to the 80+% here? Where did they all go? That's that part. I'm just gonna jump that. So main topic for today, how do we enforce that? So we have this whole bunch of different elements of dark patterns. There are probably hundreds of dark patterns. Some of that you have numbers, some of them you really can see that there is a difference in the number. With some others you don't really know, there's different, sometimes conflicting views, what gets you a higher percentage. So we try to figure out which ones are the ones that are legally, objectively easy to litigate and easy to find technically. So we try to get this overlap of what is technically easy and legally easy. Easy being a big word in this setting, but like as easy as possible. So how did we go about that? Usually most of the GDPR litigation is still paper-based. I kid you not, we had questions to get access to the files in Poland, and it told us we have to go to Warsaw, have an appointment, and a camera so we can take pictures of the paper files because there is no electronic system and they don't have a copy machine. And you only get 30 minutes to copy your file. So if you litigate in that sphere, doing anything that is remotely technical is very, very advanced. And we do have usually these kind of steps of a procedure that we do in an analog way. So we have to work out the problem, find the goals of the complaint, find the competent authorities, gather the evidence, write the individual complaints, lodge a complaint, work on the opposite submission, dispute resolution, all of that. All of that easily takes 1 to 5 years for a case, and at least 40 hours work time of a lawyer to just set it up, let alone the actual litigation. So you probably talk about 2,000 euros for one cookie banner as an NGO that runs all of that on donations. So not that cool to do 100,000 of them because that would clearly overrun our budget. So we thought more about like how a speeding camera works. And I came with an Austrian perspective on that. In Austria, the speeding cameras are basically automatic. They read the license plates automatically. They register automatically how fast you went. Then they automatically go into the registry, know who is the holder of the car, and send you what they call an anonymous ticket, which is a ticket going to the car holder. And as long as you just pay the fine, no actual procedure is ever opened. And that's the reason it's anonymous. There is no one that is officially declared the driver, so you don't get your points or whatever lost that you could get in other countries. Now, that is an extremely efficient system because you basically just transfer the money back with a code in the transfer. And that way the government knows it's paid. No person has ever has to touch it, but you still have speeding enforcement that somehow works. And that was kind of the idea how we thought, how can we use procedures like that in GDPR litigation and automate that? So in Austria, you get these kind of letters automatically sent to you. Now, our GDPR version of all of that is roughly these steps, and we would just gradually go through them. So first, we needed a target list. We need the websites that actually do these violations. Then we have to visit each page because as NOID, we always need an individual complainant. We're not like an authority that can just go after anybody. Then we need to generate the actual complaint. We then decided we send an email to the individual company and allow them to go into what we call the warning system, where they can say, okay, I fixed the problem, because we realized most of our litigation ends up with the other side giving up anyways, but just after 1.5 years of exchanges in front of a DPA, which is just not efficient for anybody. And in the end, if there is no compliance after all, go to the individual data protection authorities and file a complaint. So that was the original setup. At the end, we'll go through what we learned, what was a bad idea or which could improve, but that was at least what we started with. All of that goes in the background or went to a big MongoDB and into file system. So the big files were in that file system for the tech people, and the kind of data we derived from and scraped from the website was basically going into a big MongoDB database. So going into the OneTrust banner, it was super interesting for us that we got a test account for OneTrust, and I love to do mystery shopping because on the privacy page it's always great, and then if you become a customer, suddenly all the data is there and available and everything's possible. And on OneTrust, it was really interesting to see the standard settings as well, which again, from a litigation perspective, made sense because we could see, okay, the standard setting is that there is a reject button, but people can actively go into the panel and deactivate the reject button, and then it's gone on the cookie banner on the front end. And we went through the whole thing, and even this is actually taken from our guidance. We actually made a PDF guidance for each problem that we identified, how to fix it in the panel. So it was literally go to this domain, log in, go to this thing, click that button, and you're fine. So we tried to kind of really have it on a silver plate to kind of have them comply with the GDPR, which, to be honest, is really not our role, but it's probably useful, helpful to get stuff done. What this settings in the background generate is a big JSON configuration file. You see that file is 500 lines or whatever. And for example, here is the banner show reject all button false. So that's the setting, the technical setting that kind of switches on and off that button on the front side. And that allowed us to kind of very accurately detect if that is there or not. If you try to scrape it somehow from the page, you always have some issues and drama. If you can go right into the configuration files, you literally get it from the configuration files. Plus also from a legal side, it's easier to say, you change that part in the configuration. Here's a copy of the configuration file. You must have done that in the settings, so you deliberately remove the button. It's not that it happened to you. And all of that was quite useful to connect and also kind of then automate in the end. So we started with the target list. What we use therefore, there is a search engine called public www. And what you can put in there is code. So you don't search for a word, but you search for code that that website is using. And OneTrust at the time had all of its software under cookielaw.org was their domain. So you basically just had to look for cookielaw.org in the code of any other website to find that they're using OneTrust. And that way we already had the target list. So a lot of these technical approaches go on to scan every page in the whole web, which is crazy. With that step, you already slim it down to the biggest list of the ones you wanted. This list does not have everybody in it, and we generally went for the biggest website. So we went along the ranking, and we basically went along top-level domain. One of the biggest problems for us right now is to figure out the location of the controller of a company. Because we went for top-level domain, but for example, because my name ends on .ms, I got shre.ms as a domain, and that's, I think, some island in the Caribbean or whatever, and we wouldn't track for that. So it's interesting on how to figure that out better or have a better database or data source for that. Once we had our list, we basically have a test setup, which now changed, but basically it's on our Windows computers. So it's a computer of each individual person working at NOIP, their private laptop that they use for everything else as well. That was important because now in litigation, they all say, yeah, it may be an automated system. Who knows if there is really a person behind it and blah, blah, blah. Are you really a data subject? And that way we can say, yes, it's a data subject, it's that browser and so on. The actual test environment was in a virtual machine in Ubuntu, which we now abolished because lawyers and Ubuntu do not go together all too well. And so we now moved that into a Windows system so that they are in their home territory because this virtual machine caused probably half of the drama of this whole exercise. Because usually you need to upgrade it then, and it needed a lot of RAM that our laptops did not have in the office. And so this was kind of one of the biggest dramas in reality, where we thought, okay, it's easy, it's a virtual machine, but turns out, no. And you would basically manage the virtual machine from a browser or a web app that is opening in your second screen. So in our office, at least, everybody has two screens. So you have one kind of management screen, and the other one is where you actually a data subject and do your stuff. From that, we could automatically derive, one step back, anything that happened in a virtual machine, we automatically generated the evidence on that. So for each transaction, we got a big JSON file. We could see each transaction between the server and the browser. We have screenshots of everything that happens in there and so on, which is quite useful for the litigation later. In our normal practice, when we try to do that with 50 people, they stored the HAR file in the wrong place. The screenshot was not taken. You know, if you have humans doing 50 cases, you have like 10% fuck-ups at least because just someone forgets, stores it the wrong place, renames it, something. And the beauty about this system is no one can like make these mistakes. It's just automatically tracked in the background and also put in the right file, put in the right directory so you find it later. And that is quite useful. You could basically choose your domain that you wanted to go to. We oftentimes went with top-level domain or language. We pre-scanned that. We already scanned the pages the first time around to see if there is even a violation. And then we only went for the pages where we already automatically found a violation to actually visit it. So we tried to kind of slim down where people actually have to visit it physically. And the biggest reason why we needed to have a visit is actually to find the owner of the domain, the controller of it. I'm going to get back to that in a second. So we usually, for language reasons, divided them up in the team based on language or top-level domain. So there is an assessment, and we basically, I think the cookie banners were the most complicated thing we could have possibly come up with because they are so complex and there are so many different variants of it. If you just say, okay, there's a tracking pixel, it's binary. It is there or it's not there. In this case, we had to kind of come up with different groups and types of violations and different subgroups within the violation. So it was probably the most complex thing we could have started with, but it also meant that our system is now capable of really dealing with complex shit as well. So it's a up and a downside at the same time. We split up the cases into different violation types. So it was A, B, C, and so on. And that was, for example, no reject button or pre-tick boxes and so on. What you can see here is this first line here is the automatic pre-scan. So we saw what a week or two ago in the pre-scan happened. Then you see the second one, that is the automated scan in the situation where you're right now in. And then the third one is a human or a lawyer basically in that situation that has to kind of confirm the situation. So we basically only went if all of them agreed that there is a violation. That also allowed to make sure that lawyers don't click the wrong button, but also that the software doesn't probably capture something that is wrong. So we basically tried to really just do when there is total agreement that there is a violation. Red is if there's disagreement with the software, black if there's agreement. So with one way you automatically right away saw, okay, I still have to check this case if I'm right here or wrong here. And that's oftentimes these small things, just to change the color of it makes working with it so much more efficient and so much easier. That was also one of the learnings there. So what were these violation types? The first one is not a reject button. So usually there was just this manage preferences thing that was easy to detect. And that is something that, I mean, automation in reality, 100%. Like we just had it from the JSON file. There was never a disagreement that that button wasn't there. The second thing was that there is a pre-tick box on the second layer, because in the OneTrust system, the pre-tick boxes can only be in the second layer. That is actually one of the things we haven't verified personally, because we realized after a while that in the JSON file that's so accurate that there's just no point for us going into the second layer, checking that and so on. We just basically automatically got it from the system and went with that. The very specific thing for OneTrust is they also allow that this manage preferences thing is shown as a link. So actually this down here is de facto a button, but it's styled with the same color as the general background and with an underline so that it looks like a link. And the background is people think that a link gets you to further information, while a button gives you action. And that was kind of the design choice here to make it seem like there's nothing you can do here anymore, even though there is actually action behind that link. But by hiding it behind a link, people have the perception it's not action, but information only. And that was a very specific thing on OneTrust. There's not a lot of other software providers that do that. And is one of the things that's also in there and easy to find. One of the most complicated ones was the whole color debate. Because saying that a color is deceptive is very hard to litigate, because what is a deceptive color? Is it not reasonable individual case? So we basically had to analyze the different colors, and there was a discussion of which colors, because basically you have three colors. You have the background color, you have the button color, and then the text color. And what are you going to compare with each other? So we decided it's the button color because that's the biggest surface kind of. And then we basically compared the two with each other. If it was the same color, we basically said it's fine. Once we said it's not the same color, the computer saw it as a violation automatically. Now, the problem is that the software can only see if there's a difference, but not if that's deceptive. Because it could be basically, if you see in the next slide that, okay, you have the gray one that is probably a violation and the other one not, that works for the computer. But if you say it's green and red, that's probably reasonable colors that are not deceptive. But the computer would still find them to be different. So we basically decided for these situations, especially that the people have to, be very cautious of overriding the computer in these situations. Same thing for what we then tried. What was interesting is colors are very subjective, but then we thought about how to do contrast ratios, because contrast ratios you can calculate and they're objective. So we started to kind of calculate the contrast ratio between the background of the whole page and then the individual button. And then you can compare the two contrast ratios and say, oh, there's a different contrast ratio. What was interesting with that, I don't know if that's in the next slide, no. What was interesting in that, actually the IAB and also the W3C have minimal standards for contrast ratios for visibility of websites. So we could actually objectively say you even go below the standard for like anything that an older person can read. Which further objectified this kind of color issue, because that was my biggest worry, is like there's not really a legal, easy red line. And all of that, imagine if you have to do that manually. Like if you have to calculate the contrast ratio of each of these things manually for each case, you would go crazy. But the computer just automatically does that, puts it in a complaint, the ratio is there and so on. And we even had in that text blocks that would fold out. So you would have a first text block saying it's a different contrast ratio, but if it went below the certain threshold, there was an additional text block saying this is even below the threshold of the IAB, and then another text block, this is even below the threshold for the W3C. So you could automatically put things in the correct way. The last one that we had was the legitimate interest pay thing. That was technically a bit more challenging, because in this big JSON file where the configurations are in, we realized that there's actually two settings that have to be active to overall activate legitimate interest, which was technically a bit disturbing. So only once you analyze that in detail, and we had to go back and forth, change the settings, then see how the JSON reacts to that. That was the only way that we could actually figure that out in the end. The very last one that we had was the GDPR also requires that you can withdraw your consent as easy as you give it. Sounds like a very good objective law. That basically means you would have to have an object banner constantly hovering in front of you, because if it's as easy as giving consent, I guess you would constantly have to have a reject button down there or an object button to it. So we kind of didn't go that far, but we said it should at least be constantly visible, your option to go back. And at the time, OneTrust just started having this little icon down here where you could actually click and go back to your settings and withdraw. But most pages have not activated that. They said, oh, in our privacy policy, there's somehow a hidden link where you can then actually take your consent back. And that is actually the one thing where the websites extremely resisted to get that on, because it was against their design and it was annoying. Like the cookie banner is not annoying, but the withdraw button is really annoying. And that was interesting because that was the only thing where we could also not settle with the companies much, because that was the one thing they were like, no way that we're gonna put that there. That's that. Then on the setup, you basically have live data. So we could in the live mid situation see if, for example, cookies were already placed, if these cookies have personal data included. So we have a database of all the cookies that typically contain the personal data. And that then matches in the background. And you say, okay, you have this cookie. It also matches the personal data cookie list. We do have personal data cookies here. And then you can move forward with the case. You may sometimes on some pages, for example, have to load 1 or 2 pages until you get some cookies set. And because we operated under GDPR, we always needed cookies with personal data in it to be under the jurisdiction of the GDPR. That was kind of the background of that. Again, all of that, testing that manually. If you have cookies, if they're personal data or not, for each case, you would go crazy. And the system basically automatically does that in the background. It also basically made these screenshots, checked the cookies, as I said, the total number and the status, then went to green. So if there was a problem, it was red and you couldn't finish the case, and it told you what to do to kind of finish the case. And that also made sure that we had quality control built into the whole flow from the get-go. So case could not even proceed if there was any problem. And that is extremely useful compared to all the other cases we do usually. Then the one big thing that we still struggle with is the controller details. Sounds easy, but it's actually hard to do, because it's super hard that the computer automatically finds the contact details of a website. There is usually no automated way to do that. The biggest problem we also have is that a lot of the privacy policies say, if you're based in the Benelux, you have this controller. If you're based there, then it's this. If you're younger than this, then, you know. So they have this whole cascades of controllerships, which are probably illegal anyways, but you still kind of have to manage it. And that was one of the biggest problems, how to do that. What we started finding out is that if you just go to privacy policy, most of them have an email address. So we did have a contact system where we actually thought to automatically fill forms, because we thought most of them will have forms to make sure that there's just not traffic. Turns out hardly any forms for the privacy context, because actually the GDPR says you have to have contact details, not a form. So what worked well for us is just to search for @ in the privacy policy, and then you usually found the email address, and around that area in the privacy policy also the other information about the DPO or anything like that, or contact details. But that was like a trick that developed, is just to do search @ and a new software. The idea is that, for example, that's automatically done by the software, and it just looks for an email address in the privacy policy. You click a button, it searches it, fills it in automatically, which again saves you 20, 30 seconds on each one of them. One specific problem was with the data protection authorities. We generally automatically figured that out. That's actually wrong. That's us here. And you could basically fill in the contact details. It would kind of trim all of that. And you could fill out the country, and then automatically you would get the DPA, because we needed to kind of route it to the right DPA. One big problem is Germany, because they have 17 DPAs. And then you sit there and have to figure out which district is this and that little town somewhere in Germany. So in the background, we actually then imported the zip codes of Germany and automatically selected, once you clicked Germany down there in the drop down, it would search for a 5-digit number in the address and then try to match it to a zip code in Germany and then match it to the state. Still didn't work that well, because in Germany, I mean, it works very good actually for most of the stuff, but there's still special things like for religious organizations, there's different DPOs. For media companies, there's different DPOs. So that is still something that we haven't really figured out. That's basically then the whole visit. That's kind of the heart of this whole operation. The next thing that we had to do is generate complaints. Now, the version we did is that we basically took OpenOffice, and that's kind of a zip file. And in that zip file, you kind of have the content of it. So we just took a standard and then removed the individual parts in a zip file and put that in and out and zipped it again. And then you have the document that you can print to a PDF. That was a bit of a hacker version of doing this. And the first version was also, we said, we're just going to duct tape this together and just see if it works before we do smarter stuff. That is definitely something we have to fix. Because if you have some lawyers in the room that want to change a footnote on page 3 in 5 different languages, this has to go to the tech team to be put in there. And my tech colleague that was working on it, that's not here today, originally said, nah, it's not going to be that much. I was like, trust me, it's going to be a lot. Lawyers will always going to find something that they want to change in the text. Turns out, in reality, we convinced him that that is not something that is overly effective. So we will now actually have an interface for the lawyers where they themselves can change the stuff. I'm going to show that in a second. We then send out a warning email to individual companies where we try to especially see how we can get around the spam issue. Like if you get an email saying we're going to sue you, most people are going to be like, phishing, goodbye. And so we try to kind of put everything into an email that makes them read the email. And it was mainly that we put like the proper address up here, that we put like, you know, the blah, 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 whatever team in here, that it was always the right language for the country as far as possible. For the countries where we didn't have a language, it was English. Then we also kind of, this is a bit down, we basically had the individual domain that we visited. Then we also kind of had the data protection authority that's in charge of them in there, so that we have as many elements as possible that they're like, okay, this is genuine. They are not just fucking with us. They're really kind of serious about this. And attached to that, we basically had the PDF on it. Now, I got a bit triggered because I learned about A/B testing for cookie banners and how they do different colors and try to kind of fuck with you to actually get the consent. And I was like, can we just do A/B testing for warning emails? So we ended up having 4 versions of this email in, I think, 6 languages, which not everybody in the team loved me for. And we basically had this A/B test with a like super friendly version where it's like, we're very sorry that we have to inform you that you may have violated the GDPR, but we would be very obliged if blah, blah, blah. And then there was a more like, there was not a really aggressive one. There was just a more straightforward to say that's a violation. We will blah, 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 blah. And it was interesting to see that we basically then compared the time when they logged into our system the first time. And the neutral one in the end won, the gray one that was just like more or less saying what it is. The friendly one was actually really not performing all too well. So I think they just expected if a lawyer writes to you, it's an aggressive tone. There is apparently that. The bit more pushy one that was like more, you know, you have to do that, blah, blah, blah. Actually got opened quicker, but then in the end didn't turn out that well. So it was interesting to see these comparisons. We also got a very short version because we're afraid that it's too long and people won't read it, which also didn't work that well. So after all, the very neutral academic one actually worked, which makes me happy from a like personal level, but was also interesting to verify if it actually does. With each one of them, we attached a complaint already. So they had a PDF of the complaint that we're going to file and the guide on how to fix it. So we had basically the carrot and the stick in the same email in the hopes that that is going to be useful. They then had the option to log into a warning system, which we called We Comply. And with that, they could log in with their case number and the password. So there was no personal data or account or anything generated. They could just say, okay, this is my case number that I got in the email. And in the email, there was also a password to log in and see your case. From that, you could basically get in, see an overview of your situation. This was the screenshot that we took when we visited the page so that they can also see, okay, they have something on us. They did something here. That was a list of the violations you had. Then we were like the maximum fine, which I mean, we all know is not going to happen, but we thought, you know, a bunch of zeros is impressive as we learned on Monday. So that's that. And the email address and contact details and so on. And down here, you could again download your complaint. That was also multilingual, I think 6 languages. So if you switch to German, you would get the German complaint. If you switch to English, you got the English complaint and so on. A screenshot, and there's the option to put more evidence there as well. And then further down, our biggest problem is that once these companies talk to a lawyer, these lawyers produce hundreds of pages of bullshit as an answer, because lawyers get money by the hour, so the more hours they spend, the better it is. So we decided that there is an option to send us feedback in an online form here, where you already have to pre-select the topic and the subtopic, And we limited it to 500 characters at the beginning. We gave up on that. We are now at, I think, 2,000 characters or so. But to say, we mainly were interested in technical prompts because for legal different views, we kind of knew that we're not going to agree on anyways. But for technical prompts, that was interesting to us to see, okay, we actually tracked something the wrong way or so. So we basically then got the feedback individually, and you can see here basically the feedback of the individual person. Once they actually did the feedback and they're done, they would send that in, or the other option is that they would report compliance, so that they could say, okay, I understood, I'm just going to comply. Then they could basically fill that out and optionally fill in an email address if they want to hear back from us that we actually took back the complaint, but they didn't have to. And once they submitted that, we basically got the registration back that they complied. Now, what we haven't thought about is that people fill in that they complied and actually don't do it, that people comply and don't fill it in here, so that actually the reality and this feedback is just not overlapping. But we also realized they filled in, we comply here, then we scanned the web page. The page was not in compliance, but then complied 2 weeks later because there was an Austrian bank where they told us we need about half a year to change the cookie banner because we have like 5 different organizational subgroups that deal with our web page. And unless all of them are consulted, we cannot change that one button. And so we also had 1 month at the beginning, and we realized that in business terms, 1 month is too short. So we went for 2 months now, for example, to give them a bit more space to actually fix the stuff. That is kind of what happened there. For us in the back end, we basically got the feedback. We could filter that, for example, so we could say all the feedback on violation A, all the feedback on violation B, and so on. And that allowed us to process it much more efficiently than going through 100 emails that have everything all over the place. So we basically did that as they do with consumers that want to get something from them. So the first batch that we went in, we had basically 591 cases. We had 200 something compliance reports and 200 something feedback. So you could see that actually even in the first round, where they've never seen something like that, people actually used it quite well. And we did later in off-record talks, we actually got a pretty good feedback from DPOs. They were like, thank you for that. It was simple. I knew what to do. There was a guide of what I have to do. It's a bit weird that, we generate that from donations. It's kind of like, this... telling people what to do and how to comply is actually the work of Ernst & Young and KPMG and all these other people that make a shitload of money. But we did it anyways, and it turned out it helped. So a couple of statistics on that. Overall, we got a 42% compliance rate just from the email, which is much better than anything that happened before the DPAs. We just published on our website the statistics of all of our 800 complaints. So you can now go to the NOIB website and see for each DPA which complaints we filed and what happened in each case. Some of the people here in the first row had to type all of that into the system. Thank you. and Stefan built it. But what was great is in these situations, we have 85% of the cases that are still pending where there's nothing happening. And so this statistic is much better than anything you get out of the DPAs. What was interesting is per violation type, we basically saw that the pre-tick boxes worked really well, but that was already low because there was the Court of Justice ruling and there was not too much of a discussion about it. But what was really hard to get through is this withdrawal button that I mentioned before. So that was also interesting to see what worked and what not. The thing is, we only took back the complaint if we said they fully satisfied all the points. If there was just 2 or 3, then we just had it in the statistic but didn't take back the complaint. And that led to a situation where we still had about 18% that we could not file, but the bulk of the complaints still went onto the DPAs. Later now, I don't have the number of it, a bulk of these are also settled before the DPAs because they sooner or later give in, but that's kind of the situation here. Now, the most amazing thing about all of that was we did a second scan and wanted to do a second batch 3 or 4 months later. And we still had the original mass scan that we had and just thought we can continue with the cases. Turns out the cases that were still there, a lot of the websites were fixed over the summer. We have not written to these websites, we have not contacted them, we have done nothing. But what happened is OneTrust realized what goes on here, basically sent an email to all their customers saying, watch out, please fix your cookie banners and so on. So we had a huge spillover effect where probably way more websites that we've ever visited were actually then getting compliant, which is exactly what I talked at the beginning, general deterrence. Once you hear there's something around there, suddenly everybody gets moving. And that worked really well already with the first round of this. And was interesting because we then basically had to rescan all the pages, which it fucked up our idea of a very linear situation. And we had to kind of go through all of that a second time around. Now, that is a bit the end of the story of what we did so far. And the second part, and I don't know if you just want to talk in ideally, is what we're going to upgrade about all of that. And I guess I'm just going to join you over there.
Yeah. Yeah. So basically, the whole system was only meant to be designed specifically for one trust, and was also meant as a prototype. So this was before my time at Neub. So I just joined like 1.5 years ago. And so it was very specific on this very specific problem. And as Max already told, it was also like kind of a prototype, seeing if this whole thing flies. And it does.
So we now think about how we can get it fly better. And there's basically these individual upgrades all over here. And I don't know if you want to just talk to each one of them for a second.
Yeah, basically, you got the first part, which is the admin panel, which is now new, which means that there is a flexible interface for non-tech people to put together a batch, so like a case, more than one case.
So for example, previously we had a lot of stuff then exported to Excel, went through that, imported it back into the system, and that generated new problems and drama. So the idea is to then be able to manage all of that basically in one thing. We're going to go into that in a second.
Yeah, the second thing is to Ispettore is like the part which scans the website and collects all the evidence, does the auto scan, and also supports the manual scan. This is also upgraded now to a newer version and more flexible than before. Then all the part with making the complaint, which was formerly a lot of manual work from a tech person, which is not a good situation, is now done in a very in a way that also the legal people also can do it themselves. Then like the mailing and the warning email, basically all of that should work now more easy and flexible. And then we got a case management system, which is like our system to manage all the cases that we have opened. As you can see on the website, this is plenty. So basically, as soon as the whole thing is filed, it also goes directly into our case database, and we know what the case is about and can track the status of the whole thing.
And two things we added down here is so far we had a more linear situation. And as Stefan just mentioned, we have an admin panel to change the linear situation because we realized we just have to go back, try this again, do this again. And typical example is that we need to update the complaint. So we had the issue that the DPA said, oh, they sent you feedback. Where's the feedback? Where is that in the complaint? So we basically then had to extract that from the database, generate PDFs, attach that again. Then sometimes you had it, sometimes you didn't. So that second complaint generation will include, for example, the feedbacks that were on the website. And the other one is the verification scan. So we did do the verification scan, but we only had then the data from the feedback, from the original scan and from the verification scan, and didn't have a way to kind of automatically compare that with each other, which we, in the moment of the duct tape situation, just did in Excel sheets. And then you just move one line and everything is wrong. So that is something that will now also be possible. A couple more details. Oh, yeah.
Yeah, I like all the tool was done in Ruby using Sinatra for the tech people here, and now it's like split in half in the admin part, and all the scanning part is done in Ruby on Rails, and like all the creating PDFs, sending out the email is all done in Python and Django, which is also why? Because we got two developers. I'm the Ruby guy, and then we got a Python guy. So that's basically it.
Yeah, there is no logical reason. We were always thinking, especially if others use it, to do it in one, and we tried to get rid of any kind of other elements to slim it down to two. But because of personal preferences, I gave up on further ideas of moving that. But what from like a customer perspective, so to say, is interesting that with these frameworks, it's extremely fast how we can move stuff. Like when we manually programmed stuff, it took forever. And especially with these frameworks, you guys are usually rather quick in like adding this, putting that there. So for us, that's quite a huge help. To go more into the details, so for the admin interface, you basically have the user management and entity management moved into our case management system. Sounds very interesting because the problem is mainly that you find a company and you have to later track that that's the same company. So each company gets an ID number in our case management system, but you also have to find the same ID when you go to that website again. So you need to kind of merge that and make sure you connect the right dots with each other. Which now didn't work. So if we imported it, we just imported them as 5 different companies. And then in our system, we just had the same company 5 times. And that is something that you can manage once you can move all of that together.
Then the whole thing is now basically, so for this cookie thing, this was very specific on cookie banners. But now basically the system is able to you create a batch, which is a number of websites that you want to scan, and what you want to scan it for, you can define in the workflow where you say this and this steps has to go through, and in the steps you can specifically define what is happening there. So here you see like it's work in progress, so it's not too beautiful, but basically it's showing all the cases. So this is one of this is on my development machine. This is basically a test that I did on 900 web pages to see if the whole thing works. And basically, you can check which fields you're interested in. You can see violations and
you can then fuck Breitbart, for example, over their cookie banner. Because I just want to go forward to get the idea of a flow and the batch. So what we had to kind of separate all these different things into groups to kind of make it flow and work together. And you basically see that here. Mm.
So basically what you see is like this is the batch. The batch is basically a number of URLs that you're going to scan. A batch is linked to a workflow, which is basically saying what you're going to do with this number of URLs. And then you got the status of a batch, blah, blah, blah. And then you got in the workflow, you basically see exactly what will happen. So like you can have different versions, or you can even change within the work, while you are working on the batch, you can change the workflow. And you can say like the one version is like the easy version, and then like the second version is like with some other stuff that you don't want to have a approval step, and so you just go forward and send out the email.
So in practical terms, for example, with the first 50 pages, just checked it. Then I was on my cross trainer or elliptical, I think in English, at the gym, read through 500 pages of the complaints to realize if everything works and if everything is correct. And once you realize the system works for that batch, you don't want to have that approval step anymore and remove that, for example. So the idea was that we can, in the working system, remove steps, add steps, and the system would then react to it and just jump one thing and not do another thing. Or, for example, if we realize that there's a mistake, that we can move all of them back to a step earlier, rerun that step, and then kind of continue again without losing the data that we already generated. So there's a lot of that usability, but that from a programming perspective makes it super complicated as well, because you have to be able to react to all of these situations in the right way.
That's basically how you define a workflow. So you give it a name, and then in the end you add steps, and you can also sort them. Basically all the steps, like this is one step, is then put together in one class. So of course it's not that easy that you just put in like a simple command which says scan website for cookies, but you need to have some more code with that. But this is all bundled within one class, and therefore it's easy. As soon as the system is stable and running, you're just doing stuff in this one file, and normally it should be very hard for you to crash the system.
I try to kind of, from a lawyer's perspective, so to say, our problem is basically to scan this page, or this button is a part of the code. And we wanted to be able to kind of move that code and activate and deactivate it. And one big discussion we had is how far do you want to go? Because if each line of the code should be manually managed by the lawyers, that would be enormous. So we tried a middle solution where basically each scanning step or each bundle of things is one element. and that element the lawyer can add or remove from the process. And that allows you to have, for example, 10 steps or 1 step in it. And that is a class basically in the code that is then triggered or not triggered. So the management stops at kind of triggering a code or not. The tech people are in charge of kind of programming that code because it's too specific. But then, for example, as a lawyer, I can say, actually, I don't need that part anymore. We can jump that. And that was kind of the middle ground that we agreed on. And we'll try now for the next run to see if it works. And we hope that that is working there. Yeah, that's kind of the upgrade. I'm just going to mention all the time. That's the upgrade of the previous one where you saw kind of these different things where you click yes and no. It looks a bit different. It's kind of the Ruby framework that we have now, the Rails framework. Now, what is kind of interesting is the PDF and email generation. That was especially from a lawyer the biggest hassle because lawyers, if they're outside of Word, their world goes under. So we needed to find a middle ground between a technically workable solution and something that is like easy enough to manage and use. And the idea was to use kind of a block system. So we have that, for example, in Drupal on our website, that each one of the paragraphs is a block, and then you can edit each block. It's easy enough to understand. And then these blocks you can turn on and off, basically. And that is easy enough for the lawyers to see, okay, if that violation is true, that block comes along, and they can then generate a PDF, but they don't have to understand the full coding of it and how it all works. The idea is that they can self-manage that. And what's also part is that we can also automatically pre-translate that. For us, the biggest issue being in Europe is languages. And if everybody has to translate that manually, it's much easier if we can just run it through an API, translate it, get it back in. We usually use DeepL, which works quite well for us because it's trained on EU documents. So it actually works with EU laws quite well. That's currently the mock-up of what we have there. Not the mock-up, the kind of right now under development version. That's the part that's in Django, where you basically have the badge that you choose here, the name of this whole thing. You can have a header text, and you can, for example, make that red or have like these color options that give you a bit more room. And then for each one of them, you have a condition. So you can say this is only there if blah, blah, blah is true, if that violation was found. And you have variables that you can add. So you can basically say fill in controller name, fill in these elements, a bit like in Word if you've ever done a serial letter in Word, which most people have not. But you can put like elements in there, and then it automatically generates that. Yeah, that's kind of the same thing there. You can see that the variable that there's violation age, and then this comes along for the violation age. Yep, then last slide. For us, the long-term future, there's at least 2 things that are still kind of on the list. One thing is this controller detail issue I already mentioned before. The other one that is going to be super interesting is if we can go beyond web with all of that. So in the idea of can you do mobile apps, can you do tons of other stuff that exists? You're kind of for this mass scanning dependent that you have access to the information and you can somehow automatically find it. And a lot of the litigation that we do would rather be on something that happens on a server in the background where you simply can't scan it because you don't have access to it. But that would be an interesting part to think about how we could connect that, for example, with other developments that other people do in, let's say, the mobile apps space and how much that could connect. Where probably the inspect function would have to be done anew, but the rest, for example, of the flow could be done very much the same. One last question that usually comes along, and then I would probably hope for feedback from everybody. Right now, we don't have it out there as open source because right now it's not perfect and done. But for anybody that's interested, we're super happy to share and have it out there. We're also a bit cautious not to put it out there because there is a problem that people, for example, in Austria, we had a case where people did hundreds of complaints or 10,000s of complaints with that. Also sometimes in a deceptive way that they say, give us €100 or otherwise we file something. So we're a bit worried that if we put that monster out there, someone else will use it for not the best intentions. So right now, if anybody wants it, just shoot us an email. We're more than happy to share, but we didn't want to like drop it out there because of these concerns that are there at the same time. Yeah, that was it. Ideas, feedback, input, any other thoughts that you all have. And I know that I think it's not recommended to move the microphone, but can we just move it anyways? Because I hate the situation, to be honest.
Yes, thank you very much for your super impressive talk. One question I do have, because I have some experience with cookies, of course, not as much as you guys, but one of the things I noticed is that even if you're lucky and you are able to find a cookie banner which is kind of compliant, so to say, and quite a few times it is amazing how many JavaScripts, beacons, cookies are even placed before you put one toe on the website. So then in that world, we can have the situation that we have after your work, a world with nice cookie banners, but still we're in a shitty situation that a lot of websites are just putting it. So maybe that would be the area.
Super quickly on that. So in the technical setup, is they place them in the OneTrust setup as essential cookies, because under GDPR, essential cookies you can place without needing the consent. So they just say for all the tracking stuff, they're essential. So we did have also in the, there was one of the violation types, which was checking if the essential cookies are actually essential. So we have a list. We had a list of about 200 cookies that are oftentimes claimed to be essential, but are not essential, and that is also the ones that are placed early. So that was a specific violation type that I think was not in the presentation, but that problem we captured 90%, let's say. Yeah.
Thank you. Great work. I wanted to ask you something. In the beginning, you mentioned you go to the easy legal and technical cases. But do you take in mind the DPA differences? So, for example, the Italian DPA explicitly does not want the decline option at the first layer, and such position is the same with the Irish and with the Spanish DPA. And the same applies to other issues regarding withdrawal of consent and many other designs.
Yeah, so what we did in the complaints is we footnoted each of the, so we did a research of all the guidelines that existed of the different DPAs of what should be there or not. Turns out they all kind of go into one direction jointly, that certain things are not allowed. They don't say this is allowed usually, they just are silent on the other ones, at least in our research. Maybe that's a bit updated by now. So
there's a lot of guidelines in 2023 and 2022.
Yeah, that probably came from that project to a large extent, because I don't know. But there was then what our thinking was, they will have to come to a conclusion on a European level. There is no way that they do that differently. So they started having their wonderful task force. And now the task force, I think a couple of weeks ago, issued their final paper. And it's amazing because in that paper, there is a list of, I forgot what the option is, but say the following things are not allowed. And then there's one bullet point. And like, guys, we all know you probably had 5 bullet points here and then just deleted it because no one in the world has ever done 1 bullet point. But anyway, so my hope was that this coordination will have to happen. But turns out that the DPAs are just doing stuff all over the place. And that is exactly the problem now in the follow-up litigation, or in the follow-up with all of the cases, because my colleagues that actually have to work on all of that have exactly that situation. However, we do assume that a lot of these, the first cases we have will now go to the courts, and at some point probably go to the Court of Justice, so that we do have some decision on this. Yeah. So our hope was that with so many cases that would put so much pressure on to have harmonization, but turns out even with that pressure, we all can't agree anyways. And that was interesting because with other stuff, especially for the dark patterns, there was this dark patterns guidelines for social media. And we're like, there is no difference in the GDPR between social media and cookie banners. It's basically either it's deceptive or not. And it didn't even apply that. So that's stuff that we cannot technically solve because that's at the EDBB to solve.
My question is also on the necessary cookie part, because I came across a lot of cookie banners where there is a accept only necessary. Yes. So that gives me the hint that there are necessary. But when I look at the documents, there's nothing defining necessary. So I think that it's a technical requirement maybe. But there are websites which allow you to reject all. So when you reject all, does it still accept necessary cookies according to you?
Yes. So I can tell you from, so technically the text on the cookie banner is designed by the website. So if they say necessary only or reject all, that's a matter of what the website puts there. And at least in the OneTrust setup, it basically always allows the necessary to go through, no matter what you click on the button. And then it's just a matter of naming it. And we could, however, in the JSON file, you exactly had each necessary cookie listed. So we could automatically get it out there and find it that way. So for us, it was easier probably to read the JSON file than their privacy policy, because it was more obvious what they do in the technical documents than in the privacy policy. Maybe I'm just going to go down there later.
I'm Stuart Dresner from Privacy Laws and Business. We met before once. Anyway, the point is you've developed a fantastic management system, and I wonder whether you've offered it to the data protection authorities. You've done all the work, and they could use all this and help them manage such cases themselves. So what do you say?
Yeah, short answer on the question is I think by now we had about like 5 presentation calls or so, something like that, with different DPAs. And they were generally interested. They're generally overwhelmed by the idea, I think. So that was the first thing. They were usually interested. One issue that we have so far for the DPAs is they have national jurisdiction. For NOIB, it doesn't matter where a company is because we can file all over the place. Now their problem is, how do I go only to the websites that are relevant from my jurisdiction? Or if you take Germany with 17 jurisdictions, you can't even do .de because who knows where they are. So we would need, my first suggestion would be that we would have like the scanning phase on a European level, especially the automated scanning that you may be able to do. And again, going back to our main issues, how can we get the controller details? One option that exists is there are some business databases that kind of sell background data on business. And on them, you could oftentimes get the domain as well. So we could theoretically go to these databases, check for the domain if they have an address, and then already allocate the domain to the right DPA. Because their biggest concern so far was jurisdiction and just, that was kind of the answer, but they were very interested so far. So I think, and also one addition to that, we also built in a new system a couple of elements in that are not relevant for us, but of use for the DPAs. So we are very happy if they would use it, because we would have less work, but we'll see if that goes ahead. Thank you.
Christian Reimsma from the OECD. And my question is actually related to the previous question, because I feel like what I find really interesting is that this seems to me like to be an interesting approach how we can essentially make privacy enforcement scale at the level that it's really promising. So I was really interested to see how far are your ambitions to go when it comes to this kind of approach, and what do you conceive as realistic? I mean, you already said one of the criteria is obviously that there is a sufficient level of, I wouldn't say transparency, but you obviously need to have access to the underlying data that you want to assess. But I was wondering, how far are you thinking in going in the future? And
we're kind of still, I mean, right now, and I thought you could probably hand the microphone to the person right behind you. There was someone wanted to have a question there, or not anymore. Anyway, so the idea was that we now do web mainly, because that's simple enough. The system works. We're not going to scale that for different tracking pixels or whatever. And then we can see where we take it from there. To be honest, for us, it's a manpower issue as well. Like, this is just taking hours and hours to program. So the more manpower you have, the quicker you can try more things. And it's a resource issue. I mean, we have an overall budget of not even €1 million versus DPAs having partly hundreds. And that is where a lot of the Lex experiment is more limited. So especially for the room as well, if you have specific situations or like beyond web that would be interesting, we would be super interested if there is input. We started now with mobile apps that there is like more testing environment, but it's much harder with the environments to kind of get the data. So that would be something where we ourselves are looking for inspiration, because I think fundamentally it works really well. And it's also like how other authorities work. It's amazing to me that the data protection authorities are still totally analog. While, I mean, finance authorities, any other authority is by now digitalized and automated and yoo-hoo. And then the privacy or the data authorities are the ones that are still the most analog maybe in the way of working. So I think there is huge potential also as a citizen for getting more bang for your taxpayer money.
Hi, Dave Lewis from the DAP Centre in Dublin. I just wonder, you sort of suggested that you think OneTrust reacted a little bit to, this information coming through their clients. I mean, have you had any direct engagement, or have you had any?
So the boss of OneTrust had a phone call the next day with me. And I mean, I still knew him. He was like around on all these conferences on his little booth. By now they're huge. And yeah, they were actually, I mean, they tried, their approach was, we're Switzerland, we're just a software, who knows how to use that, which, I mean, fair enough, they can take that position. It's a problem of the GDPR that software vendors are simply not included in the law. And that was kind of their reaction. They even added like our guidelines to their website and even had a button to make like your cookie NOIB, banner like NOIB compliant. So I was like on there and logged in and was like, there's our logo on your website.
Did you charge them for that?
Yeah, so it's actually, for us was really useful because, once you get them, into the boat and get everybody into moving it, that is actually quite useful for us. And that was, I think we were very open and said, okay, there's guidelines, you can do that. We didn't try to be like aggressive in any way. And then it was actually, I mean, some people still found it terrible, but there was the more reasonable people in the bubble were like, okay, first you got a point, secondly you're very nice here, and that actually worked then quite well. So we're probably going to continue as a general way of approaching that more that direction. Are you perfect self-management microphones?
Thank you. Ezgi, I work at Timelex. So I was wondering why this issue cannot be solved by the browsers, because I'm not a technical profile, but the way I see it, if I could just mark my preferences in the browser and then it would handle all the cookie walls for me, that would be
You've obviously
dream.
not been at the workshop 2 sessions earlier.
No, I was not.
Because with Sohail, who is back there in the middle, we are actually developed this ADPC protocol, which would be a protocol like Do Not Track, where this could just basically, Do Not Track is very American and opt-out and third party. The idea was to do like with the European criteria you need, a signal where you can do that. A problem right now is unless you have a law that requires that, it's not going to happen. The GDPR actually says that there has to be a signal for opt-out in Article 21, but it doesn't define what the signal is. So if I send a signal there saying opt-out, they would be like, never heard about that signal, goodbye. And that is the fundamental problem of the legislator there, that they said it has to be there, but then there is no process of how to picking the right signal, which is a great job of whoever wrote that paragraph. And that's kind of the problem. Our hope was with e-privacy, because the discussion happened again with e-privacy, if we wouldn't want to do that because it's kind of reasonable. But as e-privacy is kind of dead by now, I don't know which one would be the next hook to get that into. One thing we discussed briefly is Reinders has this idea of a cookie pledge. No clue who had that idea, but probably some commissioner late night had a wonderful idea. So no, we're trying to do this, and that could be an option. For example, if the consent management platforms would include that signal, whatever it is, it doesn't have to be ours, whatever signal there is. That could be interesting because you could claim that it's a de facto standard, because if 90% of the websites use these cookie banner companies, these 10, all of them accept suddenly that signal, you could basically say it's a standard like PDF is a standard, or whatever document is a standard. And that could get you into litigation to actually say the other 10% now also have to do it. That would be an interesting proposition. It's very kind of edgy. I don't know if it's really going to work, but that could be a path forward to actually get a signal like that developed and a de facto standard. Ideally, it would be a standard that's democratically legitimized by the commission, let's say, in saying this is the standard and we have to do it. But there is a whole website on that, dataprotectioncontrol.org, where videos and explainers, and you can even download a plugin where you can try how this would look like in your browser. Okay. Further questions? I'm just checking for time, because we have to be out of here in 3 minutes, I think. Yes. There is a break thereafter as well, so if we overrun 2 or 3 minutes, it's probably not going to be overly dramatic. Not convinced? Okay, one question back there still. Bernardo, can you? Yep, thanks.
Ben Jorolli, University of Göttingen. I have a question. A private person set up a similar system for Google Web Fonts and scanned the web to find websites that use Google Web Fonts in a legitimate way. And that person then sent a nice letter saying, okay, you use Google Web Fonts and this is how you can use it compliant. And by the way, there was a court decision that €100 compensation is fair.
Exactly.
So if you decide to pay me some money, it would be good. Do you think this is from the enforcement perspective welcome, or is this something not so good because some person wants to get rich?
Yeah, so it was actually an Austrian lawyer, and in Austria it was all over the media, and that guy may even get disbarred because a lot of the claims in there are probably factually inaccurate, because they found out that he visited the page 1 second, and that's not realistic that any person was sitting in front of the computer there for that 1 second, but that be it as it is. I think it's highly problematic because it gets that narrative of it's not about privacy, it's only about making money, blah, 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 blah. So everything we did was always for free. And I mean, technically that still cost us probably €50 per website that we send an email to. And it would be not unrealistic to say, guys, if you cost a prom, you should probably also pay for it and not our donations. But exactly because that narrative would then appear right away, even if we would make it cost neutral, a fee, so to say, to kind of manage it, would probably not, I think is not in a PR way ever sustainable. And so automatically gets you into the world of, oh, you're just doing that for money and not for privacy reasons. So we always stayed away from that as far as possible. And that's also part of the reason why we don't want to put the code right online, because the next guy is going to use it for that. And that probably undermines the GDPR compliance even more than than having this one. That's at least my personal view. Evidence-wise, I don't have evidence what worked better. But I think especially in the discussion in the German-speaking area, there was a lot of backlash from that and a lot of like, oh, typical GDPR crazy people, they just want to be obnoxious. And it wasn't really winning anybody over, I had the feeling. And why at least that is winning over quite well. On that, I'm rather confident. So, yeah.
Okay, thank you.
Helpful.
Sorry, I have a follow-up question, which actually reminds me of some of the discussion that we see happening in the area of digital security and white hackers, where we noted that some white hackers are actually being sued because of their activities.
Yeah.
And I was just wondering if you had any concerns that you could be kind of sued because, for instance, the web scraping could be violating copyright.
Yeah, no, if you sue Facebook like fuck, you kind of get over the idea that someone could sue you back. And, I mean, I was already sued by the Irish Data Protection Commissioner and the cost was about 10 million of the litigation, so why not have another one? And no, all of that. So first of all, anything we do, there is no copyright violation. There's nothing like that you could realistically claim. So I'm not worried for substance. There could be like a slap suit, someone that just sues you for the sake of suing you. But interestingly, that never happened with us. So I think what we're arguing is not all too crazy. And that was not really the worry. We were more worried. There were a couple of people on Twitter. To be honest, especially in Germany, the discussion with the privacy lawyers is extreme. Like I've never seen that much heat in discussion as there. And there were a couple of people that said that would be a criminal offense because we would pressure people into stuff. And I was like, yeah, good luck with that. But that is a kind of the only thing I saw in that direction. And again, like the letter and everything we sent was so much on the silver spoon, like it was just spoon-fed that, you know, like if you really have an issue with that. And it's interesting because the people that complain about that are oftentimes the same people that complain that we don't warn them before. So like, so do you want to have a warning before? Then that means that we tell you we're also going to file it. Or if you don't want to have a warning before, then you're upset because you haven't talked to us. And it's just like, you know, either way, you're going to be criticized. But that's probably not because of the contents, but let's say not of the thing, but more of the contents, because, yeah. Cool, let's try to do one more question there. Being mindful of time, I'm sorry for this. We're already a minute over.
I just have ideas.
That is great.
Yeah. I was just thinking with the solution. There are two things which come to my mind with respect to the DPAs, which the harmonization is lacking. If you can, of course, you would have thought about this and tried as well. But if you can do like a discussion forum of all DPAs coming together and actually working on the design and technicality of it, you can then come up with an app which everyone will adopt. Otherwise, even if you go with one after one, the politics will kill it, number one. Number two, I think what also, because I come from an attorney background, so I know how the politics works as well here a little bit. The other idea could be how you can also write to various ministries and different governments, telling them based on the statistics that say, for example, you're getting 500 cases and that's costing the state so much amount of money where they have to invest in the judiciary and then the whole process is there. So you are proposing the same app idea to them and then they're giving the resources. So your resource problem is sorted out and then once the government has it, then the companies have no option but to comply with it. For instance, I'll give an example. I come from India. I was practicing there as a lawyer. There was a e-courts app. So it was originally developed by a private authority, subject to correction. But then later on, the idea was basic to just check what case is there on what date. And there's huge pendency of cases in my country. So it's crazy. So what that happened is later on, the government realized that's a good platform. So they started, of course, there was some lobbying and all of those things happened. And then they maybe got funding and then they got support from the government and then it's grown into an app where even if a client reaches out to me, I just open the app, tell them, just put the case number and I know what the details are, what the judges said on what date, and I can download the PDF. So, I mean,
my personal view is it would probably be the most efficient if, for example, EDB or EDPS would host that as a platform, as a software, and then all the other DPAs can log in and just see, for example, the cases for their country, because you could also with like user management manage that quite well, and you don't need 500 installations of it.
That's why the government route.
Exactly. I mean, right now we can only propose it. The reality is in many EU member states, I mean, governments even pass legislation. We just put this trap map online where you can see in each country why the GDPR is not enforced because there's some crazy law in the country that makes sure it's not enforced. So right now the politics of it is more like, how can we not have these cases ever be done, especially for concerns companies in our jurisdiction? So the dynamic is a bit the opposite, but that's definitely something. One last part that I wanted to add. What's for us interesting is, for example, in Austria, all the cases are digitally managed. There's a digital case management system for the whole republic. And we're like, it would be nice to just have an API so we can shove the cases in there. Because right now we still email them in a PDF and then they have to upload it again. And that's the same thing with the IMI system. So if we file it in Austria, because it's our concerned authority, being like where the data subject is, they have to then download it from their system, upload it into the IMI system, then it goes to Poland, they download it there again, put it into their system. So even there you have like all these breaks in between that are a bit crazy. But it's amazing to me that even the authorities cannot digitally communicate directly with each other, but have to go through the IMI. And so there's a lot of room. But I'll probably leave it at that. And there's out there the coffee area where we're just going to be there. Yeah, exactly. Thanks a lot.